People extra Ellis v. Imperati.
Good afternoon, Your Honors. My name is Anna Dean, and I represent the appellant in this case. May I ask for 3 minutes for rebuttal?
Yes.
Thank you. While recent reforms have eliminated bail for the vast majority of misdemeanors and non-violent felonies, lawmakers have expressly provided 21 categories of qualifying offenses, any one of which a court can rely on when setting bail.
Why, in your view, is the majority's framing general versus specific with respect to A versus G? Why is that wrong? It seems right, doesn't it? A is about these felonies with 2 express exceptions. G is about a particular class of crimes.
Sure. I would answer that question by first pointing out how the statute operates. It's a disjunctive statute. It's 21 separate provisions, each focusing on a different type of theme of offense, separated by semicolon and the word or. It's meant to be read in the disjunctive. When a judge sets bail, he does not go through 1, 2, 3, 4, 5. He can set bail if they qualify under any, he or she. So that's one reason that the general versus specific construction should not apply.
But reading it that way, then what happens to G? Is it meaningless?
So there's 3 points I want to make in response to that. So first, I don't think it's rendered meaningless. It means that when an individual is charged with that crime, a judge does not have the authority to set bail under that provision. It does not apply. It does
that
not.
Doesn't change the ultimate result under your theory at all. I mean, what actual meaning do those words have under your interpretation?
Sure.
And how could it actually alter what a court could or couldn't do?
Sure. I would answer that by, again, focusing on the disjunctive.
I guess I think, I don't mean to interrupt, but I guess I think it's a yes or no question. Does it have some specific effect on what a judge can do? And if so, what is that?
I think, yes, Judge, I think it does have a specific effect. It means that the judge cannot set bail under that provision for that crime. And then, in addition, I don't think that...
But for the same offense, I take it, you could do so under A under your reading, right?
Correct.
So maybe I should rephrase my question. Does it have any effect as to, from the defendant's or the court's perspective? I understand that you're saying maybe it would prevent the court from reciting that provision, but does it actually affect whether bail can be set in those circumstances at the end of the day?
Practically, no, the judge would have the authority under A to set bail if he or she deems it appropriate. It's not that bail would be set automatically.
Understood,
in every case.
Right. So in that respect, at least, the provision is nugatory. It has no freestanding effect under your reading with respect to whether at the end of the day the judge has discretion to set bail for that particular offense.
I understand that view, Judge. I would respond by saying that the principle of avoiding a superfluous interpretation, it doesn't make sense here the way that the majority used it because it rendered language in A superfluous. A is...
Well, that may be. It may be that there are 2 provisions and the reading will inevitably, whichever way you go, render one or the other effectively superfluous. But I'm just trying to make sure I understand your argument. It's not that the G somehow has some effect standing on its own. It sounds like you're saying it's one or the other. Either A will be effectively rendered superfluous or G. Is that a fair
Correct, and that's why I don't think the principle applies here to get the result at the appellate division.
So if that's right, if it's one or the other, why should we give effect to A and not to G, if that's what it comes down to?
So I think we should give effect to A because under the plain language of A, it incorporates by reference Penal Law 70.02, which expressly provides making a terroristic threat as a Class D violent.
But that seems like an argument that it can apply here. I guess what I'm asking is if we're faced here with 2 provisions that could be viewed as irreconcilable, why should we give effect to A and not to G?
Because the statute is meant to be applied in the disjunctive. If the legislature intended to exclude this crime based on its violent classification as a bail-eligible offense, it would have done so under A, and it didn't. It did it under G, knowing that it was a disjunctive list, knowing that each of the 21 categories
Well, I
focuses on
think
a
your
different
argument,
type of-
they would have had to do it under A and G, is what you're saying, no?
Sorry,
You just said that they would have had to have put the exclusion into A. But moving it from G to A wouldn't solve the problem, would it?
moving it to A would solve the problem because then it would not be bail eligible. It wouldn't be bail eligible as a violent offense because.
Well, why wouldn't it be eligible under G?
Well, G excludes it.
Well, but I've moved the exclusion to A.
Oh, sorry, I was adding it.
Yeah, so that's my question. Under your theory, they have to put it in both places.
Correct.
And any other place that this is for, because A reaches other things that are specifically reached in other parts of the statute as well, right?
Correct, and I think that all goes back to the idea that it's a disjunctive statute, that any one of these bases can apply, that they're not meant to be read one to limit the other.
But so let me ask this. If we gave effect to the exclusion in G, would that render all of A superfluous?
If you gave effect to the exclusion.
To the exclusion in
exclusatory
G?
language in G.
Would that render all of A superfluous?
No, Judge.
Okay. If we gave effect to A, would that render all of G superfluous?
No, if you see them as disjunctive statutes and merely it more
No,
represents
I'm
a.
sorry. Maybe I'm not. Does A cover everything in G?
Money laundering charges are not bail eligible on their own. So the first number of.
Under A.
Under A, they're not included under A. So there's, the first four lines in G are non-bail eligible on their own. And so that was, my understanding is that was the intent of G, is to put non-bail eligible crimes that were associated with terrorism in G.
Okay.
No, it's a lot of work for the one word "or." To ignore an express statement in G, given the one word "or" at the end of T. That's your argument. I just want to be clear.
Yes, that the framework is to apply in the disjunctive, that it's 21 separate independent bases, separated by a semicolon, and that's how we read those kind of statutes, and that it doesn't,
How
it's
would
not
you read it
reasonable
if it
for a
said
judge.
"and"? How would you read it if it said "and"?
If it said "and," it would be complicated. I would
different.
probably,
mean, it's
I would
not
probably
now?
say it was a clerical error and ask your honors to change it to "or."
So is your reading that the offenses covered by G are not covered anywhere else? They're not covered under A or D either?
So-
They're only covered under G?
So looking at G, the first four lines, all, 1, 2, 3, 4, involve money laundering charges under 470.
Uh-huh.
Those are all not bail eligible under another provision. Then at the end of the fourth line and onto the fifth line, that's when lawmakers included that language, felony, crime of terrorism as defined in 490 of the penal law, other than the crime defined in section 490-20 of such law. And so that, the felony crimes of terrorism under 490, those are bail eligible either under, as their violent classification, or some are A felonies too, which is a separate subdivision.
D, maybe, yes?
Yes,
Yeah.
yes.
So I'm not sure I'm following the answer to my question. Are the offenses enumerated in G covered only in G, or are they also covered in, for example, A or D?
They're covered, an offense can be bail eligible under multiple provisions.
Yes. So what do we make of G? Do we know why it's there? I'm just trying to understand its function, which maybe would shed some light on how we square those arguably inconsistent provisions. I thought it was
There's
mostly,
very
if
little
not in-
legislative history
Yeah.
on this, and unfortunately, I have not been able to find anything about that
Counsel, just so
particular.
I'm clear on the first answer to Judge Halligan, or the one before this, all of these crimes enumerated in G would either be covered under A or D,
Not the first four lines that involve, the offenses that involve money laundering.
So money laundering, to get a money laundering as a qualifying offense, you need G.
Yes,
Okay.
correct,
So then G is not superfluous in its entirety.
correct.
But parts of it are.
That.
In addition to.
I don't view it as superfluous, I view it as just a expression of the legislature focusing on a specific type of crime in that offense, and making a terroristic threat, it is different than the other types of crime. It's not
Okay, but just
possession
to
of.
be clear, the crime that we're talking about at the very end,
Correct.
that one, if they had not included that, it wouldn't matter, under your reading, because if it's under A. Is that
A
correct?
judge would have the permission, yes, Judge. The judge would have the permission to set bail under A.
But everything else is necessary, because if it doesn't fit under any of the other enumerated groups, right? Enumerated categories here. This group, am I right? Or have I
So-
misunderstood?
Sorry, I'm sure it's me that's not being clear. So for G, there's the money laundering offenses, and then it says, or a felony crime of terrorism as defined in Article 490. So there's a number of crimes under there. They are all bail eligible as the statute is currently written under other provisions. So they are bail eligible under this one as well as other ones. And a judge could use
So
either
some
one.
aspects of G, in addition to the exclusion, are otherwise covered in other provisions as well, not all of them, not the
Correct.
money laundering. So there's additional redundancy that we have in the provision.
Yes, and if I may, there,
Okay, so if I'm now understanding you, if everything after this last, well, penultimate semicolon, I guess, or a felony crime of terrorism, that one,
correct.
okay, you're saying that's covered somewhere else,
Yes, a judge could set bail under a separate provision, this one or that one.
on its own? Okay, so if that's true, and then the end of that, other than the crime defined in section 490.20, you're saying the first part is a redundancy, so why isn't the second part a redundancy? In the sense that it is already also covered somewhere else, but here, the legislature decided, well, now we're going to expressly exclude that.
So I would
It's
answer,
already repetitive, this last, between the two semicolons, already repetitive.
correct.
So why wouldn't we give effect to the express language
I-
in that redundancy?
I would ask that the court give meaning to the plain language of A, because lawmakers were not, their goal wasn't to avoid all redundancy when they drafted this. There's other provisions that have overlap too. For example,
But there was some intent to single out and exclude, for at least some purposes,
Correct.
the offense at issue here.
correct, unfortunately, I do not know the reason for that.
Right, we just have the text, right?
Correct, and that it's a disjunctive statute, and that the idea that these are 21 separate offenses where lawmakers were focused on a certain type of crime, and that this type of crime is different than the other ones that are associated with terrorism.
It's very strange in that it also seems to me, as you look at it now, an exclusion from a redundancy, right? They're adding that whole clause unnecessarily in a way because those felonies are already covered in either A or D or whatever it is, right?
Correct.
And then they're excluding from the redundancy, which is unnecessary, a crime, right?
Correct, and I can't tell you what they were exactly thinking then, but.
I guess the point is, do we need to concern ourselves with that when we have the express language?
I don't think so.
Why are we going to figure out some intent that's nowhere to be found when we have the clear language in front of us?
I would agree, and that clear language is under A, and the fact that these are 21
Well, no,
separate and
G
independent.
is the clear language.
The clear
because it's
language
dealing
could be
with
the
a specific
exclusion.
offense, not a general category of violent felonies. It's dealing with this specific offense.
Again, since the lawmakers knew how to exclude felonies that were classified as violent, they did it for two specific offenses under A. They didn't do it for this.
I agree, they could have written it there, but they chose to write it here.
And I would respond that because they wrote it there, it does not exclude it from A.
So it sounds to me like you're arguing that the only way they could have successfully excluded the 490-20 crime was to put the exclusion in G and in A as well? Leaving that omission in A sort of forgives the sin? Is that the
Yes.
gist of it?
That is one way. They could also just have not included any of the language or felony crime of terrorism, starting at that line, because those crimes were already covered under A.
So I'm always thinking about ice cream. And if I send my daughter to the little corner store and say, buy one of every dairy item in the store, and I write that out, and I also then write below that, also make sure you get every ice cream except not pistachio. I would be pretty surprised if she came back with pistachio. Why is that different?
So, sorry, could you repeat the hypothetical? I've been thinking about ice cream.
Go buy every dairy ice cream, go buy every dairy product in the store.
Okay.
First sentence. Second, go buy every ice cream in the store, but do not bring back pistachio.
I think that's a little bit different. It's a command coming from a parent.
As
And
opposed to the legislature.
You assume his child views it as such, but okay.
I think that's just a little bit different. I think if my daughter came back with all ice creams and including pistachio, I think I would have considered her. She didn't violate what I asked her to do. There were two different requests that I made of her, and she complied with one
But
of
wouldn't
them.
it be easier just to read, bring back all the dairy products, but instead of reading it that way, just say, don't bring back pistachio? Isn't that easier? It's clear. Don't bring pistachio.
I agree, if that were the clear command, but here in this statute.
Don't include, except.
And if they had done that in one, it would be clear. But because these are 21 independent bases, that's why
So
the
in
fact
other
that it's
words, the
excluded under G
parent,
is not excluded under
the
A.
parent could say, bring back every dairy product, but not pistachio ice cream.
Well, wouldn't they be really saying bring back, every one, or bring back everyone but pistachio? And if you did either one, you'd really be complying, right?
Correct.
And that all comes down to semicolons and ors.
Statutory interpretation,
That's what's doing the lifting.
correct. And the idea that a judge, the statute wasn't written for a judge to go through each category, 21 categories. They each have their own purpose, and they each have their own legislative intent.
But there is some importance to a judge looking to see, is there an express exclusion? And there is an express exclusion.
And I would say that's why it doesn't qualify under G. And if at some point later lawmakers determine that this crime was
I'm sorry, I don't understand that. G is the express exclusion I was talking about. I misunderstood you. Or perhaps I was not being clear.
I'm sure it was me. I would say that if the judge had somebody who's charged with making a terroristic threat, the judge under G does not have the authority to set bail. The judge does have the authority under A. And if lawmakers want to limit a judge's discretion to set bail under in such a serious violent felony, they need to do it under A.
Thank you.
Good afternoon, and may it please the court. Grace Sow for the New York Attorney General as Amicus curiae in support of the appellant. This court should reverse the appellate division's holding that courts lack authority to fix bail for the crime of
So
making...
what do we make of G?
Sure. So the exclusionary language in G is not superfluous. It reflects the legislature's judgment that unlike the other crimes of terrorism enumerated in Article 490 of the penal law, which the legislature sought fit to qualify for bail both under A and G, terroristic threats do not independently warrant bail by virtue of their association with
Well, why
terrorism.
shouldn't we read that as an implicit exception to A, which governs the specific offense that's enumerated here?
Sure. So the specific versus general canon is not...
So even set that aside. I just mean in terms of, it's an odd statute, right? Because there are some offenses which are eligible under different subsections. So in trying to make sense of that, why don't we read the exclusion in G into A?
Sure, so it's because each of the 21 subsections reflects the legislature's judgment about why a particular crime or category of crimes warrants bail because of its interplay with risk of flight. So what you have under A is any crime that is designated as a violent felony offense, which has sentencing implications, might warrant bail because the defendant would be facing a mandatory sentencing range. And it's reasonable to assume that a defendant who faces a longer sentence might be more likely to flee. That is the logic behind A. However, the legislature went through and then also set forth 20 additional categories of crimes for which it found bail to be independently warranted. And G is intended to capture crimes of terrorism. And what the language of G means is that the legislature intended certain crimes of terrorism to qualify independently for bail, regardless of their designation as a Class A felony offense or as a violent felony offense.
And what about the exclusion?
The exclusion means that the legislature did not intend terroristic threats to double qualify, like the
Oh,
other
wait.
crimes.
Isn't the crux of this that you have one provision which indicates that this crime is of a nature that it should be bail eligible, and a separate provision which says that very same crime is not bail eligible? Those are different judgments. Whatever the way it is you tee it up, those are competing judgments about the same offense and whether it is bail eligible or not, right?
So I think they can be harmonized in this way. The legislature made a judgment that terroristic threats warrant bail by virtue of their designation as a violent felony offense, which carries with it sentencing implications. It means that a defendant who is charged with this offense, if convicted, faces a mandatory sentencing range. And the legislature determined that this sort of sentencing range has an interplay with risk of flight because the defendant is facing a mandatory term of imprisonment. What G means is that the legislature independently determined that the crime of making a terroristic threat does not warrant bail by virtue of its mere association with terrorism.
Well, perhaps, or perhaps if we're now trying to put ourselves in the minds of the legislature and we have no real legislative history, we might think the legislature as a categorical matter thought, look, as a general proposition, something that is a violent felony ought to be something you can set bail on, and then said, now let's think about a bunch of specific categories of crimes. And they thought about the specific category of terrorism, and they looked at those particular crimes and said, yep, these all counts except for this one. So we could say, well, when the legislature was actually thinking about this crime in particular, it made a determination about this crime. When they were thinking about a broad category of crimes, they weren't drilling down to this particular crime, they were just thinking of a broad category. But so if we thought of it that way, which maybe is not the way the legislature went through this process at all, we might say where they actually made a judgment about this particular crime, they said not bail eligible.
I don't think that that would be the most reasonable reading of the statute because the legislature, in terms of statutory interpretation, the court does have to read the statute in a way that best harmonizes all of the subsections.
What do we make of the exclusion in A of a specific crime, which is robbery 2?
I think that that is very strong evidence that the legislature the only two violent felonies that the legislature intended to exclude were the ones that it expressly carved out of A. If the legislature wanted to also exclude terroristic threats from qualifying under A, it knew how to do so. And
Well, that just seems so nonsensical to me. Isn't the statutory interpretation first principle is you go by the text? In G, it clearly sets out this offense as excluded. That should end it, full stop. If we're wrong, the legislature can correct us.
I think unfortunately here, Your Honor, you are also contending with the plain language of A, which clearly and unequivocally qualifies the crime. So to the extent
That G is much more specific about this offense. And we have another canon about general versus specific language.
I think that canon does not map onto disjunctive schemes like this one because A through U are all equal.
But it's the only way you can write this is through the word or. Otherwise, apparently, you have some confusion if you use the word and.
That's true, but I think this court recognized just
How
last
else would
year.
one write a list?
That's true. if the legislature had intended certain subsections to be read conjunctively, they could have separated those subsections with "and." If they intended certain subsections to be read together, they could have included a cross-reference. None of those are applicable here. And this court recognized in the Brand v. Rankin case just last term that where a statute sets forth equal and alternative bases for application, restrictions on any one category should not preclude a court from taking another, nor should it be imputed to another. So I think it's well understood that disjunctive schemes do not operate in a way where one section supersedes
This is
another.
the only example in 510, 10.4, where a crime is included under one subsection and explicitly excluded under another, right? I mean, we're not going to have another appeal coming down the line with another crime that has this problem. Is that your reading of the statute?
So I actually think that K presents a very similar problem.
Really?
And that's another reason why the court should not adopt respondent's reading. So K has restrictive language that in effect says strangulation in the second degree qualifies under K only if it is alleged to have been committed the offense against a member of the defendant's same family or household. And strangulation otherwise is a violent felony offense that qualifies under A. So if you adopt respondent's reading where limiting language in one subsection can be imputed to another, you would have this
You're gonna
odd
have the problem
scenario
again.
with K, exactly.
So that would seem to support your argument that you have to read them all disjunctively, otherwise it starts to become a little bit of a mess.
Yes.
Although if I could just
precisely.
get back to Rankin, given your comment, Rankin didn't, I don't think, but maybe you see it differently, didn't involve, as it does here, clearly inconsistent language, right? Those are just alternative paths. These are inconsistent, there's a contradiction in them, because you have an express exclusion.
I think the reasoning of Rankin still applies here because there were two different bases for modifying a defendant's securing order, and one of them entailed very specific procedural restrictions.
But one didn't implicate the other, is what I'm saying. It
Yes.
didn't undermine the other, which is, it seems that would be the case here.
I think that G, again, the exclusionary language, can be read in a way that is confined only to G. It means that when the legislature said all other terrorism-related crimes under 490 qualify for bail under G, but not this one, what the legislature meant is that terroristic threats do not independently warrant bail by virtue of their designation as a crime of terrorism alone. And I actually think that the distinction between terroristic threats and other crimes of terrorism under 490 make a lot of sense, because the other crimes that you have under 490 are acts of terrorism, such as use of a chemical or biological weapon. You have acts in support of terrorism. Terroristic threats are very serious offenses, but they are distinguishable from those types of crimes. So the legislature could have reasonably determined that based on the sentencing implications of being designated a violent felony offense under A, being charged with a terroristic threat is a good proxy for increased risk of flight.
But again, I think you undermine yourself with that, because if you're going to go about the business of categorizing in the way you've just described, then you'd be clear about this exclusion in A. I mean, perhaps I'm just misunderstanding the argument, but I find it very difficult to follow.
I guess I'll try it this way, which is that there are many crimes that can qualify for bail under multiple subsections under the statute. So rape in the first degree is another example. It's both a violent felony offense and a Class A offense. And so I think that recognizing that crimes can qualify under multiple subsections, the exclusionary language in G just makes clear that the legislature did not intend terroristic threats to qualify under G, but it doesn't mean that it does not intend terroristic threats
I
to
guess
qualify altogether.
The problem with that you might be hearing from some of us is that it seems like an awful waste of effort. They create this section, terrorism offenses, and then they say this one, however, is not a terrorism offense for the reasons you said, which all makes sense. But don't worry about it because we included it somewhere else. Why bother, I guess is the question.
I think it really goes back to the overarching structure of this provision, which is that the legislature set forth 21 independent bases or 21 categories of crimes for which it thought that that type of crime was a good proxy for increased risk of flight.
And it
for
seems like
which-
it did so without looking back to see if it was covered someplace else, and if so, how to square that.
Exactly.
Is that
and-
fair?
Yes, that's fair, and that's exactly the case with K as well. So it's just a product of the statutory scheme. I just also, if I may briefly emphasize that if you were to adopt respondents' reading of the statute, you would also have issues with other purportedly general provisions like R and S. R, for example, qualifies any felony offense that's committed by a principal while on probation or a term of supervised release. And if you read the exclusionary language in G to exclude terroristic threats from ever qualifying, then they also could not qualify under R or S. So you run into many problems with the statute that you do not run into if you accept our reading that the subsections
Well,
are
R
disjunctive.
and S don't have any express exclusion in them, right?
That's true. R and S do not have any express exclusions, and that's why any sort of carve-out in G or the limiting language in A should not bar a crime from independently qualifying under R and S. But under respondents' reading, you would be reading subsections like G together with an R and S to prevent certain crimes from qualifying if they are carved out of another subsection.
Well, G would only carve out making a terroristic threat from R and S, is what you're saying, or no?
Sorry, I should clarify. I'm saying that if you accept respondents' reading,
Yes.
then terroristic threats would also categorically be excluded from R and S.
Or the crime in K, I would assume.
Yes,
Right.
exactly, and that's
Right,
not,
it would be a determination that bail could not be set for making a terroristic threat,
yes.
under any provision.
Under any
Right,
provision,
yeah.
and I think that's contrary to the broad language of R and S.
But it seems to be the logical conclusion if you have expressed language that excludes a terroristic threat.
I think, Your Honor, to the extent there is sort of an irreconcilable conflict that you find between G and A, you can also look to what sparse legislative intent there is. I think if you look to the other types of threat-based crimes that the legislature chose to qualify under A, you have crimes like falsely reporting an incident in the second degree or placing a false bomb or hazardous substance. It just doesn't make sense for the legislature to say that these types of threat-based crimes are qualifying but exclude terroristic threats without there being any indication in the history that the legislature was particularly keen on excluding terroristic threats. So to the extent there is any sort of ambiguity that you find in the statute or the text of A does not plainly resolve this case, I think you can look to the legislative history and divine the legislature's intent to include this crime.
Thank you.
Thank you.
Good afternoon, may it please the court. My name is Andrew Ellis of the Dutchess County Public Defender's Office. I'm here on behalf of Respondent Michael Cavagnolo. As has been robustly discussed today, we're here before the court on a bread and butter issue for this court. It's statutory interpretation. It's whether or not making a terroristic threat qualifies for bail, as the people are arguing under subdivision A, or whether it's specifically excluded under subdivision G. Putting forward that it is specifically excluded for subdivision G, the courts are instructed, as has been set numerous times by this court, repeatedly in precedent, that we have to come to a harmonious reading between the two statutes. It's always been brought up that we also have to apply a general rule only where there's
Well, why doesn't the approach in Rankin apply? Why aren't they right about that?
well, as you stated before, it's a different situation.
Taking the other view now.
Well, then I'll say a ditto, but more specifically, as you stated, there are two different hearings that are contemplated, two different standards. There's different things that are being contemplated by them as well. One was drafted, I believe it was in the 1980s, and the other one was drafted in 2019 by completely different legislatures. And by doing one, you're not prevented from doing another. However, it was very distinctly decided by this court that once you proceed, you have to decide which way you're heading.
But couldn't if you wanted to be clear in the way that, and interpret it the way you're proposing, couldn't the legislature have said in G, notwithstanding any other subsection of 510.4. Could have been precise about it if it was isolating the terroristic threat, even though perhaps otherwise covered by other subsections, and ensuring that it would have no coverage elsewhere.
They could have done that, but just because the legislature was not as specific as the courts may wish, which I feel like.
Well, I guess I think maybe it's a little bit different than just specificity. Isn't it a question really of whether you read A and all of the other, I think it's 21, if I have the right number, provisions separately unto themselves as discrete units, right? Or whether we take what's in G and we import the exclusion to A. That seems to me that that's in part a question about the structure of the statute. And so why shouldn't we treat it, as your adversary says, as 21 discrete provisions and not imply?
So I'd answer with 3 reasons for that. The first being that there's no indication that we should read it like that. And to be frank, I don't think I've ever heard of another reading of this until the dissent from the Appellate Division, Second Department, stated these as 21 separate categories.
Well, there is overlap elsewhere. And I guess what I'm asking is just in terms of the structure of the statute, it's I guess, possible, but I'm not sure typical to import language that the legislature decides to insert in one provision and not in another, and imply it. The legislature could have put it in A, it could have clarified it in G. So why should we make that textual move?
Well, this court has also repeatedly held that we should review statutes as a whole and construe each and every subdivision, subparagraphs of that statute as a whole, right?
Well, related to that, though, I was very intrigued by the Attorney General's argument that the structure of the statute is meant to allow courts to, find a box where the crime under consideration fits, not to have to review all 21 subdivisions to see if something else knocks it out. So in response to your rhetorical question, why would you do that? It is arguably more efficient if you read it that way. What's wrong with that approach to it?
Well, I've made my first 2 points. My third point, actually, is that the statute states a principal stands with a qualifying offense. It doesn't say that he stands or she stands charged with a qualifying category of offenses. It doesn't have the previous or under every single subdivision. There's no textual indication that this was read to be categories. When we look to the origin of the statute, and maybe not the original origin of it, but what I mean by that is the Bail Elimination Act of 2019, there weren't 21 categories. There was only 9. It stopped at subdivision I. We've gone through 3 subsequent amendments of that where they've expanded it repeatedly. And when you look to...
So would you read K the way your adversary then is suggesting, that it would have to be read under your interpretation, that specific crime is excluded related to family members, I believe it is?
I would. So it is, but there are numerous instances where there are actually violent felony offenses that are under 70.02 of the penal law, and they are included throughout the statute as well.
So I want to see if I understood your response to Judge Canataro's question, which was it that, so you said the statute reads a defendant stands charged with an offense. Do I take from that answer that your answer to his question about efficiency is that what a judge would do is not run through all of these 21, but would say, is there one that deals with this particular offense, and go to that one and determine it under that and not have to look through the rest? Is that what you were saying? So here, in this particular case, because the charge is a terrorism charge, you would say, okay, G deals with terrorism, so that's the one I look at.
They could do that. In reality, what all practicing attorneys, I would assume DAs, defense attorneys, judges, they all have a cheat sheet to this. As soon as it came through, everybody made cheat sheets. They're distributed through the I believe through the unified court system, as well as our office has their own, I believe the district attorneys has their own, because it would be very cumbersome for somebody in court every single time to go open it up, look through each one, and try to figure out. We'd be spending way too much time on that, so we create shortcuts. We
So
look
why
at it.
would the cheat sheet direct you to G and not to A in this case?
The cheat sheet would direct you to everything. So it would go through every single offense listed under 70.02 of the penal law, which are the violent felony offenses. You'd also look at all of the sex offenses. You'd have to look at all of the broad brush strokes that are in 510.10.4, as well as all of the specific statutes that are in there. And if you run into a conflict, you'd have to resolve that through the interpretation of the statute.
Yeah,
Counsel,
but
could we
why-
go back
I guess
to-
I don't understand, sorry, Judge Garcia, the difference between the general and the specific. Because to me, A is very specific. It incorporates expressly a statute, which expressly lists this, and then it excludes two specific statutes. So I really don't understand why we're referencing that as a general statute. It's very clear. A is very clear in my mind about what it's doing. And how do we reconcile that with our canon of expressio unis, which we say, there's an irrefutable inference that everything else is included unless it's specifically excluded. How do you get around that?
So clarity does not mean that something's not general, right? So it is very clear. It's supposed to be the violent felony offensive 70.02. It's also very clear that 490.20 is supposed to be excluded, right? So the clarity is not what's in question, it's whether or not it's general or specific. While both are referring to a statute, you look into 70.02, and there's numerous statutes within that, can't give an exact count at the moment, of that are listed therein.
But
Whereas-
why isn't it better understood as sort of like different fonts of jurisdiction, right? So in a federal case, you could have diversity jurisdiction or federal question jurisdiction, and they're totally separate grounds to go into court, right? And if you have a restriction on one, you don't import it into the other because they are distinct. Why isn't it 21 different, I think this circles back to Judge Canataro's question, 21 different grounds on which a court can find an offense bail eligible. And so therefore, whatever G says doesn't bear on what A says.
If these were broken up into different statutes, perhaps we would be looking at it like that. But
But
this
the
is,
fact that they're in subsections makes it different?
yes, because
Why is
everything's all in one spot, one place. With your example, you're looking at different types of jurisdiction, right? And those aren't all going to be in the same place. Whereas here, everything is a list. Not only is it a list, this is a complex list, which is why you have the difference between the commas and the semicolons throughout this, right? So we're looking at a list of qualifying offenses, not a list of qualifying categories.
Yeah, but there's
Counsel,
still an
can I
or
just
in there.
ask one question here? Do you agree that or a felony crime of terrorism as defined in Article 490 is redundant? That that's also covered by A or B or one of the other sections?
That portion of it is covered under another portion, yes.
So it seems to me the legislature thought there was value in adding that section to G.
Yes.
Why couldn't that same approach apply to there is independent value to taking the threat part out of G? If there's independent value in adding to G when you have it in some other section, why isn't there independent value to taking it away from G when you have it in another
So
section?
let's, not to cut you
No,
off.
sorry.
So when we think about it, how would you have made a list? You're going to get together and you're going to look at the penal law as a whole, right? And there is structure to 510.10.4. If you look at subdivision B, they're looking at witness intimidation. C's looking at witness tampering. D's looking at A, felonies. E's looking at sex trafficking. G's looking at terroristic crimes. H is looking at criminal contempt crimes. I is looking at...
And eventually, we're going to get to the
Yeah, we
answer to
could
my
go
question.
through all of them, but there is structure.
But
And
why, if there's value to add something to G independently, why isn't there also value independently on taking it out of G?
Well, we have to read the text of the statute that is there. It's within there, and so we have to give value to it. When we're looking at perhaps the legislature is going to decide that 490-20 shouldn't be a violent felony offense, but they're not going to change 510-10-4 whether or not it's a qualifying offense.
I
right?
don't understand how the argument you just made supports your overall goal here. If you're conceding that each subsection is a category, and obviously G is terrorism offenses, and I think we can all agree that because of the exclusion, just like your adversaries have argued, 490-20 is not a terrorism offense, it's still a different kind of offense that qualifies whatever the category defined in A is, felonies that qualify under 7002. So I'm, all I'm hearing is it's not one category, but it is another category, which is equally valid, isn't it?
No, so I'm not saying that it's a category. I'm saying that there's structure, and when you look at this, it makes sense why they would have done this, right? We're making a complex list. So we have to look at how do we organize this list in a way that might make sense, but that doesn't make it that it's a category of offenses that qualify. It's just how you would organize it, it's how you would debate it. When
Didn't you
this-
just list a series of categories for each subsection? I thought I heard you do that. I can't repeat it because you obviously know the statute much better than me, but you said each subsection sort of deals with a general type of crime.
A policy decision, yes. So it's not a category per se, right? But they are making a list in a way that makes sense, right? What wouldn't make sense is if there was no structure to it at all. We wouldn't expect them to just willy-nilly put some in under A and B and C and D. And if we're going to argue about it in court, especially in an arraignment court where we're trying to process through cases quickly, we are going to want to say, Judge, it qualifies if you look under subdivision A or subparagraph D, that's a very quick and easy way to get to it versus if they would have made one long laundry list, it would have been much less clear. This is just breaking it up to make it easier to read through. And if you look at the semicolons, it's not just that there's a semicolon after each subparagraph. If you look specifically at G, you can count the semicolons within there. There's 5 semicolons within subdivision G. So the argument that these are different categories, it wouldn't even be that there's only 21, there'd be even more of them when you start to break up within G. The reason why I think the semicolons are there is simply, again, to provide clarity when reading through the statute. There's nothing that I've ever seen or heard until the dissent said that these are categories. Never heard or seen anyone ever refer to the list of qualifying offenses as categories. It's always been referred to as a list. These are the offenses that do, and these are the offenses that don't qualify. And I believe there was a question that was asked about expressio unius est exclusio alterius. In my research, I found about 78 cases that the Court of Appeals has ruled on utilizing this specific statutory maxim. I could not find a single case where it has ever been used within the same statute. What I mean by that is normally the court would take it to compare 2 different statutes and then read them together. I have never found a case where, and I can 100% say within the last 25 years, because I've read through each one of those line by line, that it exists where it's in one subdivision of the paragraph, but it's not in another. So typically when we're looking at it, the court has simply never applied it in that way before.
Thank you.
Thank you.
Just briefly, I want to iterate that my adversary and I use different cheat sheets for determining whether a crime is bail eligible. Under mine as well as the lower courts, making a terroristic threat is a Class D violent felony. It is bail eligible because it plainly falls under subdivision A. The statute is disjunctive, and there's no indication that exclusion from one is exclusion from all. If there are no further questions, I would rely on my brief.
Thank you.